Good day, everyone. My name is Scott Reich, and this is Crime Talk. Yes, this is the weekly recap of all the top stories throughout the week, conveniently located in one location. We hope you enjoy the show. Thanks for watching, and we'll see you next time on Crime Talk. Accused Delphi murderer, and things are getting a little spicy there indeed. So the attorneys for Richard Allen, or I guess I should say former attorneys, have filed another brief with the Indiana Supreme Court asking them to now throw the judge off the case, just like they were thrown off the case. The writ of mandamus was filed by two attorneys not directly affiliated with the case against Richard Allen, and they're alleging that Judge Fran Gull had ruled against Allen's constitutional rights and that she should be replaced as the judge. Now, the defense team is citing Allen's right to a speedy trial under Indiana law. Now, as you may recall, Judge Gull took over and replaced the original judge to bring stability after a highly publicized arrest of the suspected killer 5.5 years after the bodies of Abby Williams and Libby German were found dead of stab wounds in a wooded area near the Monon High Bridge outside of Delphi, Indiana. The original defense team ran into conflict with Judge Gull with what they admitted was a zealous defense and a couple of inadvertent evidence leaks, as they described them. They were confirmed in late September. Well, the September leak included crime scene photographs to social media posters and reportedly led to one leaker's suicide. Now, Judge Gull said she found the attorneys to be grossly negligent and ordered their removal from the case after a televised October hearing. Now, another attorney has petitioned the Supreme Court to reinstate the former court-appointed defense team. They stated, in order to protect Allen's constitutional right to a speedy trial, the High Court should replace Judge Gull for her alleged prejudice and bias towards Allen and release the transcript of the closed-door meeting with the judge and the previous attorneys. Now, the meeting in Fort Wayne was where the judge reportedly threatened to ruin the attorney's professional reputation by detailing what she believed was gross negligence in open court. So either withdraw, basically resign, or I'm going to embarrass you. The judge also set a new trial date in the case after appointing a new defense attorneys, a guy by the name of Robert Scremin, S-C-R-E-M-I-N, and William Labrato. Now, the attorneys already filed the brief with the Indiana Supreme Court to question Judge Gull's oversight of the case, claiming she violated the public access by keeping several filings secret. And just as recently as this weekend, Judge Gull asked the Indiana Supreme Court to grant her more time to file a response to the petition filed by the defense attorneys. The new date was granted until November 16th. So there you go. I told you early on, this is weird, okay? The sideshow has become the circus. Now, the defense attorneys definitely got very creative and were very zealous in their defense of Richard Allen. A lot of people, particularly the prosecution and the police, were quite offended by the attacks that took place in their briefing. And as you may recall, we read it. We did a live show. We read nearly all of it, I guess I should say, to you, so there'd be no misunderstanding. It was pretty detailed, and they go after the police and the prosecutors pretty hard. Judge didn't like that. Okay, there was a leak. Okay, get that. There's a remedy for that. It's called sanctions against the attorney. But to kick them off, to say that there's a conflict so great that they can't remain on the case, I've never seen anything like that before. We'll see if they get much relief. I'm not sure what's going to happen, to be honest with you, on this one, because I've never seen anything like this happen before. So hold tight. It's going to get good. Yes, we've finally heard from the clerk of the court in the Alec Murdoch case. And guess what she's saying? Liar, liar, pants on fire. That's her defense. All right. So today, the South Carolina Attorney General's office filed an answer and a motion to strike in response to Alec Murdoch's request for a new trial and a new judge over allegations of jury tampering by the clerk of the court. Now, as you all know, Alec Murdoch was convicted of killing his wife and son back on March 2nd after a 6-week trial there in Walterboro, South Carolina. But the legal battles involving the disgraced lawyer are not over. So after filing an appeal, Murdoch then filed jury tampering allegations against the Colleton County clerk of the court, a woman by the name of Rebecca Hill, and most recently filed a motion for a new trial and a new judge to oversee his old case as well as his ongoing cases as well. Well, on November 7th, today, the Attorney General's office, which is prosecuting all of the more than 100 state criminal charges against Alec Murdoch, filed a 25-page response to Mr. Murdoch's motion that included an affidavit from Hill denying each of the allegations. Now, the state calls Murdoch's claims broad and based on statements from one juror who was removed for dishonestly concealing her own improper communications about the case, and 2 hearsay affidavits from Murdoch's counsel's own paralegal. Now, the state further argues several key points in their motions. First, Murdoch advances a sweeping conspiratorial theory about wholly irrelevant Facebook posts with scant evidence to support the allegations. Next, while jury tampering allegations are serious and may require an evidentiary hearing, the law does not permit highly motivated convicts to put their own jury on trial. And Juror 785, who was dismissed from the service as a juror after alleged improper communications outside the courtroom, is now making the allegations against Ms. Hill, despite telling a different story when questioned earlier during the trial. Now, Murdoch's counsel did not object when Juror 785 was dismissed for improper contact with other jurors and others, and a Juror 785 who claims Hill tried to influence her was not on the jury that deliberated Murdoch's guilt or innocence, and therefore they shouldn't be legitimately concerned. And no other juror clearly corroborates statements made by Juror 785. Now, certain statements attributed to the allegations by Juror 630 to Hill closely resemble statements made during the trial by the prosecutors. 2 of the affidavits Murdoch's legal teams are using to support their arguments are from Holly Miller, a paralegal working for Murdoch's attorney, Rich Harpatulian, and the state claims that they are inadmissible hearsay. Well, technically, everything is hearsay unless it's under oath in court. So the attorneys know better than that. Anyway, the affidavits regarding the jurors' thoughts about evidence are not admissible under the state's criminal codes and procedures, and the state moves to strike Mr. Murdoch's claims that Ms. Hill tried to influence the jury in order to get a guilty verdict and the ultimate book deal. And they also added that only Alec Murdoch could conceive of such a confounded gambit as even remotely plausible, and he is projecting his own calculating, manipulative psyche onto a dedicated public servant in order to save himself. And none of the other jurors who were willingly interviewed about the allegations by the state police reported feeling any pressure or influence to reach their verdict. So after the allegations came about, state police questioned Hill and the majority of the jurors, and the attorneys for the state attached to their filing an affidavit signed by the court clerk, Ms. Hill, denying the numerous allegations made by Juror 785 and Murdoch's legal team. Now, Ms. Hill denies telling the jury not to be fooled, watch him closely, look at his actions and movements in regards to Murdoch's conduct during the trial. She denies telling the jury this shouldn't take us long to reach a verdict. Ms. Hill denies ever discussing evidence, witnesses, and the substance of the trial with the jury. She denies having a private conversation with a juror in a bathroom. She denies handing out media business cards to the jury during the trial, and denies asking jurors their opinion on Murdoch's guilt. She denies threatening a juror and her husband. She denies withholding smoke breaks from jurors until they reached a verdict. And also attached were affidavits from 9 jurors who, while they don't agree on every detail, all state they do not feel pressured in any way by the clerk of the court, Ms. Hill, to reach a guilty verdict. Also attached to support the state's case are several affidavits from Ms. Hill's court staff. Now, it's unclear when the Supreme Court there in South Carolina will rule on these motions and if a hearing's even going to be scheduled anytime soon. So, my thought on it is this. We shouldn't do criminal cases based upon affidavit. Frankly, that's like civil trial stuff. Ooh, I've got an affidavit. No, you have an affidavit. And they submit that instead of saying, let's come in to court, answer questions in front of a judge in a witness stand after taking the oath to swear and affirm under the pains and penalty of perjury that they're going to tell the absolute truth. Well, here we have a question of fact. Now, although it's one juror, it could be the one juror. Apparently, some of the other jurors didn't want to talk about it or didn't want to sign their name to any of the affidavits saying, oh, the clerk did not do anything improper. Apparently, several of them did. Well, guess what? It sounds like we have a question of fact to decide. Who is telling the truth? Now, everybody in the law knows there's a jury instruction that's given. It says the mere number of people appearing to support a certain proposition does not necessarily prove the proposition. So that's saying, well, I got 9 people and you've only got 1, doesn't mean that the 9 are telling the truth or telling the whole truth. So I hope the Supreme Court there orders a hearing and have these witnesses testify under oath. And in South Carolina, they still put their little hand on the Bible and see what they say. And obviously, the judge should probably be taken off the case as well, given his comments regarding the case in various interviews to both national TV as well as to a school, or his law school that he spoke at. So those are my thoughts on that. Will mark exactly 1 year from when police discovered the bodies of Kaylee Gonsalves and her best friend Madison Mogan, as well as Zaina Kernodle and her boyfriend Ethan Chapin. Now, there have been numerous court appearances for Bryan Kohberger, who entered a plea of not guilty to all of the charges. And when Bryan Kohberger appears in court, he is dressed out like he's going to a job interview. Pretty unusual. Well, Kaylee Gonsalves' mother, Christy, says that Kohberger's behavior and dress in court absolutely makes her sick. She said, quote, "It makes me sick that he sits there in his suit and he sits there and taps his little hands." She also noted that she's a little shocked and disgusted that Kohberger is not in handcuffs or shackles when he goes to court, or he's not in his little orange suit. Now, Kohberger initially attended hearings in a traditional orange jumpsuit, but shortly after that, he began wearing a suit and tie to all of the court appearances. Now, obviously, that has to be approved by the court. Now, the Gonsalves also represent that they believe that Kohberger has been given 5 suits, video and computer access in the jail, as well as special treatment to including his vegan meals while in custody. Now, let's mention this briefly. Normally, when a defendant goes to a hearing pretrial, they are in the jail garb, whether it's a traditional green suit, orange suit, or the black and white stripes. They're in the traditional jail garb. It is very, very unusual for a defendant to appear dressed in civilian attire pretrial. At trial, yes, you have to let somebody dress out. I had a guy once that didn't want to dress out. He wanted everybody to know he was in custody. And we were doing really good for a while until he started spinning around, when witnesses were being questioned, and he didn't like what they were saying. But anyway, you get the gist. It's unusual. Now, only time I've ever seen, frankly, a defendant appear in a suit that's in custody, show up in a suit, well, it turned out to be the Lori Vallow case. So I'll be honest with you. It must be an Idaho thing, because most detention facilities, most sheriff's deputies will tell you, man, we don't have the resources to dress somebody out. Well, why is that? It's not like you just hand them a suit and they go through it. The people working at the detention center have to go through it, make sure there's, not a handcuff key sewn in it somewhere. It needs to be stored. And can you imagine if everybody wanted to dress out going to court and there's 80 people on the docket? Nothing would ever get done. Now, I don't know if I haven't seen any motions filed to have Bryan Kohberger dress out, because normally you need a court order from the court saying, dress this person out for trial. So I haven't seen anything filed, so I don't know why it's done. Maybe it's an Idaho thing. Maybe somebody can help me out. But I've never seen pretrial defendants appear in court. I've seen occasionally somebody show up for a sentencing because they knew that was really going to be the last time they were ever going to wear a suit or civilian attire again. So, we've asked for it and the judges granted it, but never for pretrial hearings. All right. Now, back to the Kohberger matter. Now, FBI agents returned to the crime scene last week, October 31st, as well as on November 1st, to conduct further investigation. Apparently, they are making some sort of 3D demonstration model for trial. Now, as you may recall, Bryan Kohberger was supposed to go to trial in October. Obviously, that didn't happen. And once again, under kind of an Idaho thing, when you waive speedy trial, there's no next, when you waive speedy trial, oh, now we got to get you trial in the next 6 months. It can be waived indefinitely. Now, I understand it's a death penalty case, but a year has passed. Somebody needs to get this case going because, one, the public, the family, the victims, everyone needs resolution in this case, as does Bryan Kohberger and his family as well. And remember, I think one can argue that the state, in this case the state of Idaho in the Bryan Kohberger matter, has just as much right to a speedy trial as does the defendant. Something to think about. Let me know, do you think Bryan Kohberger is getting special treatment? We brought you this news last night because it kind of broke last night on our live show. Normally we do it on a Tuesday, but we had to schedule it for last night. Anyway, the judge in the Bryan Kohberger matter has issued an order stating that the state shall, and that shall is very important in the legal world because a shall means you shall do it. No exceptions, not a please. Will you try to get it done? You may do this. It's a shall. And the court states the state shall provide to the court no later than December 1st all of the IGG material pertaining to this case that is in the possession of the FBI and the private laboratory the state contracted with. Now, of course, the judge says, unless the state can demonstrate some good cause for an extension of time, you got to turn it over. Kind of wishy-washy there at the end, but you get the gist. Turn over all of the genealogical information that the prosecution and the FBI relied upon to develop their DNA profile as it relates to Mr. Kohberger's father, which ultimately led to Bryan Kohberger. They're entitled to it. I said it a long time ago when it was requested. Prosecution should have turned it over. I don't know why we're playing games with this. It just delays the trial. As you know, we were supposed to start trial on October 2nd in the Bryan Kohberger matter, and, well, we haven't. Whether it was tactical reasons or they wanted to have this information, the defense has waived speedy trial, and so we have no Chad Daybell. He wants to hold the prosecution, well, to their words, their arguments that they made in the case of Lori Vallow. And lots of times I think it is very important not to put any spin on it, just to give you the facts. So the attorney, Mr. Pryor, for Chad Daybell, has filed 3 motions. And I think the one that's probably the most interesting is the motion in limine to limit the state to consistent arguments on behalf of the defendant's relative culpability. All right? So Chad Daybell has filed 3 motions.